All right, this is case number 19 CR 188, State of Ohio versus Bentley Chad Penwell. You're Bentley Chad Penwell appearing from the jail. Are you Bentley Chad Penwell appearing from the jail? All right. Apparently can't hear me there at the sheriff's office. Mr. Penwell? All right, call out the jail bin and tell him that they need to turn the volume up because he's not reacting.
Mr. Barnhart, if you could mute yourself, I'd appreciate that.
Ms. Collins, I'm a host of this meeting, so don't be giving instructions to other people. But I appreciate everybody being muted until they're called upon.
Okay. All right.
Mr. Barnhart, could you mute yourself, please?
Mr. Collins, at the victim witness, can you hear me?
Judge, you're muted. If you're talking to us, we can't hear you.
All right. Okay. First of all, Ms. Collins, do not give instructions to other people in this meeting. If somebody is, I did not hear anything back from Mr. Barnhart. If there's a disruption, I'll take care of it. But participants in this hearing, you wouldn't speak up in the courtroom. You're not going to speak up in a Zoom meeting. Don't do that again. All right. Now, Mr. Penwell, can you hear me at the jail?
Yes, sir.
All right. This is case number 19 CR 188, State of Ohio versus Bentley Chad Penwell. Mr. Penwell is appearing by Zoom from the sheriff's office. His attorney is Danielle Witt, appearing from her office. Appearing from the prosecutor's office is prosecuting attorney Collins. The defendant was convicted of aggravated possession of methamphetamine, a fifth-degree felony, and was placed on community control back on May 8th, 2023. He was, I'm sorry, not May 8th, January 24th, 2020. The allegation of alleged violations was filed on May 8th, 2023. Court informed Mr. Penwell of that and appointed Ms. Witt to represent him. Now, Ms. Witt, are you and your client both in agreement that this matter can be conducted by Zoom rather than in-person appearance?
Yes, we are.
And you're all right with that, Mr. Penwell?
Yes, sir.
All right. Now, Ms. Witt, have you had an opportunity to review the allegations with Mr. Penwell?
Yes, I have.
All right. Is he going to admit or does he wish to have a hearing?
He is prepared to admit to them.
All right. Mr. Penwell, the notification alleged that you had violated Rule 2, that on or after 3/13/2020 you failed to report to the probation department. Rule 7, that on or before 5/7/23 you used methamphetamine, amphetamine, and MDMA. Rule 13, that on or about 3/13/20 you left Massey House against staff advice and never returned. That was signed by probation officer on the 9th of this month. Looks like you signed it on the 8th. Now, those are the allegations. You understand those allegations?
Yes, sir.
And you understand that you have a right to have a hearing and to require the state to prove that you have committed these violations? And you have a right to present evidence, contest that, to cross-examine those witnesses. Do you understand that?
Yes, sir.
Has anyone promised you anything or threatened you in any way to get you to admit to these violations?
No, sir.
All right. Do you have any questions? And now, if you admit, I can do one of three things. I can continue community control under the same conditions previously ordered. I can continue with additional conditions that I think are appropriate. Or the third, the most serious, is I can revoke it, sentence you to prison for 12 months, fine you $2,500. You understand that?
Yes, sir.
All right. With that understanding, then, is it your decision to admit to the violations that were filed against you?
Yes, sir.
All right. Anything from the state or the probation department regarding disposition?
Yes, Your Honor, we would request the defendant's community control be revoked and that he be sentenced to a term of incarceration. And I spoke with Ms. Judicial, and they have no further recommendations for treatment for him at this time.
I need jail time credit, Dan. All right, Ms. Witt, on behalf of the defendant.
Yes, Your Honor. Well, I spoke with Bentley. He is prepared to take accountability for his actions and his violation. He obviously has a significant drug problem and knows that prison is likely. Would like to ask for the opportunity for STAR, but like I said, is willing to be accountable and try to get himself under control.
All right, Mr. Penwell, anything you'd like to say?
Yes, sir. I do need treatment, sir. But I'm willing to take, action for my accountabilities, and I don't know if Ms. Sturgill's out there or not, but can I say thank you for everything that she did from when I was in the Maxey house and everything she did for me. She's good people. I just want to say thank you to her. I appreciate that. But yeah, I really do need treatment, sir. But I mean, that's up to you. Either way, I mean, I wouldn't have left if it wasn't for my mother getting sick and dying. I got to spend 2 weeks with her before she passed. But I mean, I wouldn't have left in the first place. And I just went on. I isolated myself for over 2.5 years, and finally got out and got the job, and ended up getting caught here. You know what I mean? I know I should have done turn myself in. It's I admit that. I was just depressed, and it was a rough time in my life. It still is, but that's all, sir.
All right. Well, Ms. Penwell, you have a really extensive record, and you were put into the drug court, and you didn't even last a month. And you walked away from treatment, and you never came back. You never, it's been 3 years. So, one of the first rules of succeeding on community control is to at least report and stay in contact with the probation department. And if you wanted to leave treatment there, then you should have contacted them, and they could have potentially, most likely, have found another placement for you. But you didn't want to do that. You just took off. And I guess the only thing surprising about the case is it took 3 years for you to get caught. But, sooner or later, it always happens. And so there's just nothing that the court can do under that kind of circumstance other than sentence somebody to prison. So it's a judgment order of the court that you be and are hereby sentenced to the Correctional Reception Center at Orion, Ohio for a period of 10 months to be given 12 days of jail time credit. And upon completion of that prison term, it is possible the Adult Parole Authority may place you under post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised by a parole officer in the terms they set, and if during that period of time they determine that you have not complied, they can return you to prison to make you serve an additional period of up to half of the prison term for one or more violations. However, if you commit a new felony, then in addition to whatever sentence the judge in the new case can impose upon you, the judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. You're also ordered to pay the court costs, which judge will grant an execution order. If you fail to do that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court can permit you to do community service once you've been released from prison, not while you're in prison, and give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
No, Your Honor.
All right,
No, Your Honor.
you're remanded back to custody. Thank you. All right, Robert Hawkins would be next.
Just before the door shut behind you.
All right, this is case number 22, CR 195, State of Ohio versus Robert O. Hawkins. Are you Robert O. Hawkins III?
Yes, Your Honor.
All right, the defendant has entered a plea of guilty to aggravated possession of methamphetamine, a fifth-degree felony. The court referred the matter for a pre-sentence report to receive that, and this is now before the court for sentencing. Mr. Hawkins is appearing by Zoom from the jail. His attorney is Danielle Witt, appearing from her office. Appearing from the prosecutor's office of Prosecuting Attorney Collins. Ms. Witt, do you and your client both agree that this matter can be conducted by Zoom rather than an
We do.
in-person appearance in the courtroom?
Yes, we do.
You're all right with that, Mr. Hawkins?
Yes, Your Honor.
All right, have each of the parties had an opportunity to review a summary of the pre-sentence report?
The state did, Your Honor.
Okay.
Yes, Your Honor.
All right, anything from the state regarding sentencing?
Only what's contained in the plea agreement.
Ms. Witt?
Yes, Your Honor. We also asked the court to follow the joint recommendation. Robert has a significant drug history, and I believe began using drugs, it looks like, at the age of 13. And I think is finally willing to and wants to turn his life around for the better and seek treatment and to be clean and live a clean life. So we asked the court to follow the joint recommendation of STAR and community control.
Anything you'd like to say, Mr. Hawkins?
Yes, Your Honor. As Daniel Witt was saying, I've been clean almost a year now. I was seeking treatment myself before this case was opened, and before I knew about this case. I was planning on going to the bars for accused reentry. So with STAR, my plan is after STAR, I can go straight to TCC transitional and live a clean, sober life.
You received community control out of Fayette County case, right?
No, that case is done with.
Okay, I know you served time. I thought that you were still on community control. Now, what's the situation with your Ross County case?
I'm shooting for STAR on that too,
Well, what's the charge down there?
for receiving.
Receiving stolen property?
Yeah.
And do you have a court date on that yet, or an upcoming court date?
May 30th.
And what is that going to be?
My first
Pre-trial?
pretrial, yes.
All right, so you haven't had any pre-trials, and the case is still open then?
Yes, Your Honor.
And you're being held down there in lieu of bond, correct?
Yes, Your Honor.
All right. Well, I'm going to go ahead and approve the plea agreement because I had thoughts of you being put into drug court. I think you would be a candidate for it. But one thing's a problem here. You're not going to be able to go to STAR next week unless the judge down there releases you because you're being held there in Ross County. So we have a bed available at STAR. I think it's on the 31st, next Wednesday. I think that's the date. Yeah, next Wednesday. But you have to be released from Ross County. So I don't know if you've talked to your attorney about that or not. But what I'm going to do is this: it's ordered the court should be sentenced to 3 years of community control under the supervision of the probation department. Under these conditions, you obey all laws of all jurisdictions, conduct yourself law-abiding manner at all times. You report when and as directed. You'll be required to be truthful with all statements that you make to the probation department regarding your supervision. You are to keep them informed of your residence, place of employment at all times. May not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may you communicate or attempt to communicate with anyone who's an inmate in those facilities without prior written permission. Now, because of your numerous convictions, you're prohibited under both federal and state law, including this case, from possessing, purchasing, owning, or using, or having under your control any ammunition, dangerous ordnance, weapons of any other type. And possession of any firearms, ammunition, or dangerous ordnance would be a violation of both federal and state law that subject you to prosecution. And you're not to have any of those while you're on community control. You may not purchase, possess, use, or have under control any type of controlled substance, drug abuse, CBD, oil, kratom, or any variant or analog of any controlled substance that has effects similar to those, nor may have any instrument, device, or thing that may be used to administer those without prior written permission. You're to submit to without a prior legal prescription, and you must provide a copy of that within 24 hours of receiving it. You're to submit to drug testing when and as directed. You do not purchase, possess, use, or have under your control any alcoholic beverage or be present at places where the sold or being consumed is otherwise lawful. You're not to associate with anyone who's a co-defendant in this case, nor any other person who has a criminal records, member gang, or any other group who has in the past or could in the future influence you to commit a criminal offense or violate these conditions unless approved in writing by your supervising officer. To the date of this order, you may not marry or establish cohabitation, a common law marriage type relationship with another without written permission. You must provide your financial or your supervising officer with financial information records or your ability to pay any fees or costs to be reviewed. You must report any contact with law enforcement or any arrest, citation, or conviction or other charge of violating the law not later than the next business day after that occurs. If you're referred by probation department for an evaluation or assessment for any treatment, therapy, counseling, training, or educational program beyond that ordered by the court, you'll submit to that if any programming is indicated. You'll enroll in and complete that successfully. You'll be required to pay the court costs of this action and make payment arrangements to do that. You're to successfully complete the STAR and aftercare. You'll have to, if you are not released from there, from Ross County to STAR, then you'll have to report to the jail 3 days prior to a bed availability as notified by the probation department. So like I said, right now, you know, if you can check your attorney when you get back to Ross County, if you can get them to release you to STAR, then you can go there, but otherwise you're going to stay in jail until they release you. Then you'll contact the probation department. If you are released from custody down in Ross County without going to STAR, then you'd contact the probation department immediately. In fact, contact them as soon as your case is completed in any event so that they know what's going on. So you'll need to report to them. Now, by being placed on community control rather than being put on in prison, you're deemed to have consented to a search without a warrant if your person, residence, vehicle is owned by you, used by you, or any other property placed that's under your control where you're found at any time by any officer of the probation department. There'll be no fine or license suspension. You are ordered to pay the court cost and as a condition, and you're also ordered to pay those as a substantive order, and if you fail to do that, then the clerk of courts could collect that through various means, including levying on bank accounts, wages, earnings, or other assets that you may have. If that doesn't collect it, then the court could order you to do community service and give you credit for each hour you worked in an hourly rate set by the court. Each hour you work, reduce your judgment by that amount until paid in full. Now, in the event that it's alleged that you have failed to comply with these conditions, then the probation department will file written notice at the court. There will be a hearing, and you'll be entitled to have an attorney. If the outcome of that hearing is that you failed to comply, then at that time you could be sentenced to 12 months, fined $2,500 if that occurs. Upon completion of that prison term, it is optional with the adult parole authority. They could put you under post-release control supervision for a period of up to 2 years. They don't have to, but if they do, you'll be supervised by a parole officer under their terms, and if they determine you fail to comply, they can return you to prison, make you serve an additional period of up to half of your prison term for one or more violations. But if you commit a new felony, then in addition, whatever sentence the judge in that new case can impose upon you, the judge is also authorized to sentence you to an additional period of 1 year, whatever time's left on that period of post-release control, whichever is greater for committing that offense while under post-release control in this case. All right, is there anything further from counsel?
No, Your Honor.
All right,
No, Your Honor.
thank you. Danielle Denowitz, please.
Doug, you doing okay? Thanks. It's just the door behind you.
All right, are you Danielle K. Denowitz appearing there from the jail?
Yes, Your Honor.
All right, this is case number 23 CR 14, State of Ohio versus Daniel K. Denowitz. Present, she's appearing by Zoom from the jail. Present on behalf of the defendant is attorney Danielle Witt. I'm sorry, Jake Wagner. Appearing on behalf of the state is prosecuting attorney Collins. Mr. Wagner, you and your client both agreeable this matter be conducted by Zoom rather than an in-person appearance in the courtroom?
We are, sir.
You all right with that, Ms. Denowitz?
Yes, Your Honor.
All right. If you should need to talk to your attorney during this hearing, just let me know, and I can put the two of you in a breakout room where you can talk without anyone hearing or seeing you, okay?
Okay.
All right. Ms. Denowitz has entered a plea of guilty to illegal conveyance of drugs of abuse onto the grounds of a specified governmental facility, a third-degree felony. The matter was referred for a pre-sentence report. I have received that and reviewed the same. Have each of the attorneys received a summary?
The state has.
I have as well, Your Honor.
All right. Anything from the state regarding sentencing?
Only what's contained in the plea agreement.
Mr. Wagner?
Likewise, Your Honor, you may have an updated letter. I have one dated 10th of this month indicating that there is a bed available for her at the Recovery Council should the court go that way. I know she's not had the greatest record with this court on some of her counseling, but hopefully this time in lockdown with her freedom being taken away kind of shed some light on what could happen if she doesn't follow through with the treatment, Your Honor. So we would ask the court to follow the recommendation of the parties.
All right, Ms. Denowitz, anything you'd like to say?
No, Your Honor.
All right, well, it's the order of the court then that you be placed on community control for a period of 3 years under the following conditions. You're to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, report to the county probation department when and as directed. You must be truthful in all statements you make to them regarding your supervision. You must keep them informed of your residence, place of employment at all times, but not change either without prior written permission. You may not leave the state of Ohio at any time without prior written permission. You're not permitted to enter upon the grounds of any correctional facility or communicate with anyone or attempt to communicate with anyone who's an inmate in those facilities without prior permission in writing. You are prohibited from purchasing, possessing, owning, using, or having under your control any kind of a firearm, ammunition, dangerous ordnance, weapon of any other type. You're not permitted to purchase, possess, use, have under your control any kind of a controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of any controlled substance that has effects similar to controlled substances or drugs of abuse, or any other instrument, device, or thing that may be used to administer those or prepare them for administration, unless you have a lawful prescription, a copy of which must be provided within 24 hours of receipt to the probation department. You'll submit to drug testing when and as directed. You're not to purchase, possess, use, or have in your control any kind of alcoholic beverage, nor may you be present in places where they're sold or being consumed, even if it's otherwise lawful. You're not to associate with anyone as a co-defendant in this case, or with any other person as a criminal record, a member of a gang, or any other criminal group, or any person who has in the past or could in the future influence you to commit a violation of these conditions, unless that's approved in writing. You may not enter into a common law marriage type relationship or marry with another person without written permission. You must report any contact with law enforcement or arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You'll provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed. If you're referred by the probation department for an evaluation or assessment for any treatment or therapy or programming beyond that ordered by the court, you'll submit to that. If there's a recommendation that you complete that programming, you'll enroll in and successfully complete that. You'll pay the court costs of this action and make payment arrangements to do that. You'll remain in the Highland County Jail until you're conveyed to STAR, or TRC, which is scheduled for May 22nd of this year. Then you'll be released to go there then. You'll be required to successfully complete the transition TRC treatment for substance use disorder, SUD, and aftercare. Now, by being placed on community control rather than being sent to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you, used by you, or any other property placed that's under your control where you're found at any time by any officer of the probation department. There will be no fine or driving suspension. Well, there's no driving suspension for this anyway. Now, you're ordered to pay the court cost, and you're to make payment arrangements for that and make those to the clerk as a condition. But if you don't do that, in addition to being a violation, it will also subject you to being subject to collection measures by the clerk or courts, which could involve levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion or then the court could order you to do community control and give you, community service and give you credit for each hour you worked in an hourly rate set by the court. Each hour you worked will reduce your judgment by that amount until paid in full. Now, in the event that it's alleged that you have failed to comply with these conditions, the probation department will file a written notice of that with the court. There will be a hearing. You'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, then at that time the court to revoke your community control and sentence you to prison for between 9 and 36 months, fine you $10,000. If that happens upon completion of that prison term, it is possible, or it's mandatory, I should say, it's optional. It's optional that you be put under post-release control for a period of up to 2 years under the supervision of the probation department. If the adult parole authority. And if they determine that you have failed to comply, then they can return you to prison, make you serve an additional period of up to 9 months for a single violation, up to a maximum of half your prison term for all violations. But if you commit a new violation or if you commit a new felony while under supervision in this case, then in addition, whatever sentence that could be imposed in that new case by that judge could also sentence you to an additional period of 1 year, whatever time is left on the period of post-release control in this case, whichever is greater. And if that occurs, that must be served consecutively sentenced in the new case. All right, is there anything further from counsel?
No, Your Honor.
sir.
All right, you're remanded back to custody. Thank you.
Thank you, Your Honor.
Thank you.
Still supposed to be both.
All right, are you Nicole Pierce appearing there from the jail?
Yes.
All right, this is case number 23 CR 69, State of Ohio versus Nicole Jacqueline Pierce. Ms. Pierce is appearing from the jail by Zoom, and her attorney is Danielle Witt, appearing from her office. Appearing from the prosecutor's office is Prosecuting Attorney Collins. Ms. Collins, I know there's a victim representative in this case, or filed. Is that victim or victim representative present for this hearing?
They both are.
Okay, they're on the screen, marked Sarah Covert.
Yes, and Zachary Barnhart.
Okay, all right. Now, do either of them wish to be, well, in this case, it's a legal issue, so I don't think they have anything to contribute.
I'm not sure that there's anything for them to talk about.
Yeah. All right. Now, the court ordered a competency examination as well as an examination of the defendant's mental state at the time of the alleged offense. The court did receive that report back on May the 10th. Have each of the attorneys had an opportunity to review the report?
The state has.
Yes, Your Honor.
All right. Either party wish to add anything in the way of evidence to the report?
The state does not wish to.
No, Your Honor.
All right. Well, the examiner has then determined that the defendant does have the ability to understand the nature and intent, purpose of these proceedings, and to assist her counsel in her representation, and has recommended that she be found competent, so the court does find the defendant is competent. Also, they found that there was no support for a filing of a plea of insanity, although one has not been filed. So the case is restored to the active docket. We will set a, let's see, if we had any pretrials in this case, I don't recall.
I believe so, Your Honor. Yes, we did on 4/19.
All right, so we'll set this for final pretrial then on June the 7th at 1 p.m. Trial date will be set for July the 10th at 8 a.m. Speedy trial time is told per 2945.72C and the same bond conditions will remain. Is there anything further from council?
No, Your Honor.
No, Your Honor.
All right, your attorney will be in touch with you, Ms. Pierce. Thank you.
Thank you.
All right, that's everybody in jail. All right, okay. All right, that completes the Zoom. Case number 23 CR 24, State of Ohio versus Aaron Dale Hunt. Present for the state, Assistant Prosecuting Attorney Adam King. Present on behalf of the defendant is J.D. Wagner. You are Aaron Dale Hunt.
Yes, Your Honor.
All right. Mr. Hunt has entered a plea of guilty to the failure to comply with the, I think that's what it was.
Yes, sir.
Here it is. Failure to comply with the order signaled to police officer, a third-degree felony. The matter was referred to the probation department for a pre-sentence report. I have received that. Have each of the attorneys received a summary?
State has, Your Honor.
Defense counsel has, sir.
All right, Mr. Wagner.
Your Honor, we've just asked the court to follow the recommendations of parties. I believe the state did recommend community control with substance abuse, counseling. Again, my client, in speaking with him today, being candid with the court, I think the last time we were here for sentencing in one of the pre-trials, he had not been stellar in the guidelines that you'd set up for him. It's my understanding now he has seen the error in his ways. I know his counselor, I believe, from Soda Payne Valley is here with him. The court would like to inquire. It's my understanding from speaking with Aaron, he's working 6 days a week, so he's keeping himself busy, so he doesn't have idle time on his hands. Again, this is his first felony, Your Honor. We would ask the court to follow the recommendation that he continue with his counselor who has shown up here today, Your Honor.
Anything you'd like to say, Mr. Hunt?
Couldn't stay down.
Sorry. Yeah, I realize I made a huge mistake. I had some hiccups at the beginning of my pretrial supervision. Sorry, and I'm doing the right things now, and I'm trying to continue to do those things. I want to live a clean and sober life for myself and for my kids.
Where are you working?
No, I'm at Burton's Junkyard. I'm working every day now. I was there before I got laid off for a month and a half, but I'm back there every day. So.
Yeah, at the time of the pre-sentence report, you indicated you hadn't returned because of the case. So, but when'd you go back?
Yeah, I've been back for about a month now, I believe.
All right.
Yeah. Yeah, I work from 9 to 6 every day. So.
All right, anything further?
No.
All right, well, it's the order of the court then that you be and are hereby sentenced to a period of 3 years of community control supervision under the supervision of the probation department of the following conditions. You may be seated. You're to obey all laws of all jurisdictions, conduct yourself in law abiding manner at all times, report when and as directed, be truthful in all statements you make to the probation department regarding your conditions. You're to keep them informed of your residence, place, and employment at all times, may not change either without prior permission. You're not permitted to leave the state of Ohio without prior written permission, and you must have that pass with you when you do leave. You may not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who's an inmate in any of those facilities unless you have prior written permission. You're not permitted to purchase, possess, own, use, or have under your control any firearm, ammunition, dangerous ordnance, or weapons of any other type. You're not permitted to purchase, possess, use, or have in your control any controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of any controlled substance that has effects similar to controlled substances or drugs of abuse, or an instrument, device, or thing that may be used to administer them or prepare them for administration, unless you have a lawful prescription, a copy of which you must provide within 24 hours of receipt. You're to submit to drug testing when and as directed. You're not permitted to purchase, possess, use, or have under your control any alcoholic beverage, nor may be present in places where they're sold or being consumed, even if it's otherwise lawful. You're not to associate with anyone as a co-defendant in this case, or any other person has a criminal record, is a member of a gang, or other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or to violate these conditions unless that's approved in writing by your supervising officer. After the day of this order, you may not marry or establish cohabitation or common law marriage type relationship with another without prior permission in writing. If you must provide your financial information and records so that your ability to pay any restitution fees or costs can be reviewed. You must report any contact with law enforcement on any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You'll pay the court costs and make payment arrangements to do that. And there's no restitution, correct?
Correct, Your Honor.
All right. Yeah, you're also ordered to comply with your treatment plan at Soda Paint Valley Mental Health. Now, by being placed on community control rather than being sentenced to prison, you're deemed to consented to a search without warrant of your residence, your vehicles, your person, or any other property or place or vehicle that's under your control or where you're found at any time by any officer of the probation department. Now, there'll be no fine. You are ordered to have your suspension of driving privileges for 3 years commencing today. That's mandatory under the law. You're also ordered to pay the court cost as a substantive order, and if you don't make payment cost or don't make payments on your restitution, in addition to being in violation of the terms of your community control, the clerk could also then take collection measures to collect that, including referring to collections agent, which could result in levying on property or accounts or any other assets you may have. And if that doesn't collect it, then in addition, then the court could order you to do community service and give you credit for each hour you work. In and out of the rate set by the court, each hour you work, reduce your judgment by that amount until paid in full. Now, in the event that it's alleged that you have failed to comply with these conditions, then the probation department will file a written notice at the court that will be hearing. You'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, at that time the court will revoke your community control and sentence you to prison for a period of between 9 and 36 months as provided by law, and fine you $10,000. If that happens upon completion of the prison term, it is mandatory under the law that you be put under post-release control supervision by the probation department or by the adult parole authority for a period of at least 1 year up to a maximum of 3 years. If that occurs, or not if that occurs, but if it will occur if you go to prison and serve your prison term. If during that period of time you fail to comply with those conditions, then they can return you to prison even though you serve the entire term set by the court for an additional period of up to 9 months for any single violation, up to a maximum of half of your prison term for all violations. But if you committed a felony, then in addition to whatever sentence a judge in a new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. All right, is there anything further from the council?
No, Your Honor.
All right, then this completes your case. You're not on pretrial supervision anymore. Report to the probation department so they can transfer your case to the felony supervision unit. All right, thank you.
Thank you, sir.
Dylan Harner. All right, this is case number 23 CR 20, State of Ohio versus Dylan Harner. Present for the state's Assistant Prosecuting Attorney King. Present on behalf of the defendant is Attorney William Armentrout. We do not have a defendant present. The matter was set for sentencing at 1 o'clock, along with several other cases. It's now approximately 1:41 p.m., and don't see him in the courtroom. Mr. Armentrout, do you have any knowledge as where he may be?
No, he showed up for probation on 5/4, I was told. I left him a voicemail not too long ago. The only thing I could offer you, I remember we had a conference about this because he's got a sentencing in Claremont County. I don't know if he was going here first and then be transported down there. You put an order on, but I don't remember.
Oh, that's right.
So I don't know if he was gonna be, maybe he's down there today, I don't
It
know.
was supposed to be brought back.
No. Scheduled for sentencing tomorrow in Claremont County.
Right.
Oh, he's sentenced tomorrow. Okay, gotcha.
We had the order.
Oh, yeah, that's right. That's right.
I think you said maybe he could be released from here, because the recommendation was for a sentence to be imposed, so.
Right. Well, for some reason, I thought it was the day before our sentencing, but it's not worked out that way. So we'll have to defer our sentence, have to continue this then until Tuesday, May, that'd be the 30th. Make sure I don't have anything. I don't think I have anything that morning. Do you know what your schedule is?
No, no.
I forgot Mr. Harner's still in Claremont County. They're not sentencing him till tomorrow. No, he went down there and we thought he was going to be sentenced.
Your Honor,
Judge, I don't know that he's in
I
Claremont
don't
County. I
believe
was,
he's in custody in Claremont County.
Huh?
I don't believe he's in custody in Claremont County.
There was an injury in the file.
Yeah, we did the injury, but we didn't,
Well, he was in our jail.
No, he was out on bond.
Why did I have a warrant for his removal then?
you didn't. The injury you had me do, we laid it in the file not to be filed until today.
Oh, that's
And
right.
it should be somewhere. I laid
Okay,
it-
now it brings it back. Okay. Yeah, okay. We were anticipating that he would be sentenced today.
yes.
He would be held here, transferred to Claremont County, sentenced there, returned here, and be conveyed to prison.
Yes.
Yes.
All right, that was the reason. Okay, yeah, okay, I'm clear now. I'm sorry about that. Okay, well, then we're not going to continue this. He has failed to appear, so we'll issue a capias for his arrest. And we'll deal with him when they catch him. All right, thank you. Gavin Faulkner. All right, this is case number 23, CR 35, State of Ohio versus Gavin S. Faulkner. Appearing on behalf of the state is Assistant Prosecutor King. Appearing on behalf of the defendants, Attorney Jacob Wagner, and you are Gavin S. Faulkner.
Yes, sir.
All right, Mr. Faulkner has entered a plea of guilty to count 1 as amended of aggravated trafficking of methamphetamine, a third-degree felony. The matter was referred for a pre-sentence report, which I have received, and have each of the attorneys had an opportunity to review the summary?
State has, Your Honor.
Defense counsel has, sir.
All right, anything from the state regarding sentencing?
Only was contained in the plea agreement, Your Honor, and the restitution in this case is $80 to the task force. Thank you.
Okay, Dan? Yeah. All right, Mr. Wagner, anything you'd like to say? Thank you.
Only, Your Honor, I need to ask court to follow the recommendation. In so much, obviously, you never want to see your client go away in handcuffs, but I understand that. Because of the facts behind this case, the state has been lenient, cut us a deal on this matter. We would obviously just, I know it's part of the plea agreement, we just hope that the court will seriously take, I know my client's behavior counsel on this, the judicial release that we would file in 6 months, Your Honor.
All right, Mr. Faulkner, anything you'd like to say?
You don't have to, but.
Ask him for like, 3 days or so to just.
You can ask, but he's not going to grant it. But I cannot deny you the opportunity to ask him.
All right, Your Honor, so, since I was, bonded out, right, been on house arrest. The only time I'm able to leave is when I go check in with my PO or if I'm going to a Fed recovery. I just asked that I be given like 3 days or so just to, in that house arrest order lifted. Just, to see my mom and my dad before I go.
Do you not see them now?
No, I'm not allowed to leave the house.
I mean, I'll continue to, if the court would be inclined.
Pardon me?
I know the court doesn't like to have a report. If the court's inclined to continue it, I can look on my schedule. I mean, I know.
No, I'm not inclined to continue it.
Okay.
Okay. Anything further? All right. Well, it is a judgment of the court then that you be in here are hereby sentenced to the Correctional Reception Center at Orion, Ohio for a period of 24 months. You'll be given credit for 14 days. You were arrested on the 27th of February. I'm sorry, arrested on the 16th of February and released on the 17th, correct?
No.
It's not correct?
I think I was arrested the 13th and I was released the 25th.
Okay. Yeah, the bond was posted on the 27th. You were released on what day you say you were arrested, the 23rd?
The 13th, I
The
believe.
13th? Okay, you were brought before the court on the 17th of February, which was a Friday. And according to the sheriff, you were arrested on the 16th, so that's what I'm going to go with. Because you would not have sat in jail from the 13th until the 17th to be arraigned. So you'll be given 14 days of jail time credit. And if you come up with evidence to the contrary, then you can provide that to court and I'll look at it. Now, upon completion of this prison term, the Adult Parole Authority may place you under post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised under the terms they set. And if during that period of time the APA determines you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term for all violations. But if you commit a new felony while under post-release control, then in addition, whatever sentence the judge in a new case could impose upon you, that judge is also authorized to sentence you to an additional period of 1 year or whatever time's left on that period of post-release control, whichever is greater, for committing that offense while under post-release control in this case, and that sentence has to be run consecutively to the sentence in the new case. You're also ordered to pay the court costs when judgment grant executes his order. If you fail to do that, then the court clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then you can be permitted to do community service once you get out of prison, not while you're in prison in this county, and you'll be given credit for each hour you worked and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. All right. The court is not going to defer execution of the sentence. You've been on bond now for 2.5 months, and look at the PSI. Your father is unemployed, so if you wanted to see you, he could have come and see you. Your mother lives in Greenfield. She works. There's no reason that they couldn't have visited you. So I'm not going to permit that because I've just had too many cases of people that I did this, didn't report. And every one of them said exactly what you're about to say. Oh, I promise you, Judge, I will. So just save your breath. I'm not going to do it. Doesn't matter what you say, you're not going to change my mind. So you're remanded to custody.
Your Honor.
And he's also going to pay $80 in restitution to the
And the mandatory fine.
I know. Mandatory fine is waived since he has appointed counsel. All right, you're remanded. All right, this case number 9 CR 182, State of Ohio versus Philip E. Ritter III. Present for the state is Assistant Prosecuting Attorney King. Present on behalf of the defendant is Jacob Wagner, and you are Philip E. Ritter III.
Yeah.
Mr. Ritter was convicted in this court of possession of drugs and possession of criminal tools, and was put under community control for a period of 3 years on April the 7th, 2010, and on October 6, 2011, that was terminated successfully after he complied with all the conditions, paid all costs, and he's been discharged since that date. The court has received a request for sealing of the record, and I did order a report and have received that, reviewed that. Now, anything from the defendant, Mr. Wagner?
Only, Your Honor, I didn't handle this original plea. It was the late Mr. Pence, so I don't know a whole lot of facts, how the deal was structured, beyond what's journalized here. It's my understanding this was a marijuana charge. He completed all the probations, paid every fine and cost. I think this is the case. It's tailor-fit, or tailor-made, shall I say, for the sealing process. I don't believe the state has an objection. We just asked the court to seal the case, Your Honor.
Mr. Ritter, anything you'd like to say? Anything you would like to say in addition to what your attorney said?
Anything you want to say?
You have.
Just reason I'm here, I'd like to have a clear record and get the privileges that I once had back and continue on.
Mr. King, anything from the state?
The state has no objection to the motion, Your Honor.
All right. Well, the report shows that Mr. Ritter, this is only felony convictions he's ever had, and therefore the court will grant the motion, and it will be ordered that the records be sealed. There will be an entry filed that will be sent out, and you'll get a copy of it, and you'll need to keep that and make several copies, keep them in different places, because if you lose one, you'll have to come back up here and get a copy, and they'll be sealed, and they, if somebody doesn't know what's going on, they might say, you don't have a record, and you'll say you'll have to get a court order, so just avoid that. Now, also, Mr. Wagner, the law just recently changed on April the 6th on the sealing of records, and now a person that has a record sealed can actually have it expunged 10 years after they become eligible for the sealing. And for these offenses, I think it's 1 year after the sealing, or after he was discharged, which would have been, wait a minute, let's see. Let me, tell you what, have a seat, let me go check that, because this may be eligible for expungement, which means that the records are destroyed. Let me go check that, because he was discharged on the
2011.
October 2011. Would you go into my desk, where my computer is, and there's a drawer on the right, in the bottom right drawer, there's a file that says sealing of records. Would you bring that in? Or maybe just sealing. Yeah, the difference here, Mr. Ritter, is that the record's sealed, it could be looked at in the future by law enforcement or the court if you were in trouble again. But if it's expunged, then the records are destroyed, and then never, so they're gone. So that's what I'm looking at, because it can be done. Because when did you file this? You filed this, I think.
Well, I was going to say, Your Honor,
You filed it before the new law became effective.
Well, I was going to say, I'm telling on myself, Your Honor.
Yeah.
Like you got on me this a couple years ago, or a year ago.
Yeah.
I didn't change my headings from expungement to seal.
Yeah, you got it right, and now they've changed it back.
And now they've changed it back.
Well, they actually have it. Now, see, what happened is, essentially, there was no expungement. They still called it this, so they did away with it. But now, under this new two-tier system, you can apply and get your record sealed, and then 10 years after that date that you're eligible to do that, you can apply to have them expunged. And the expungement is actual destruction.
Okay.
Under the old law, expungement just meant they were not subject to inspection. So let me look here. Yeah, he was eligible to file 1 year after his discharge, which would have been October of 2012. Okay, so this was filed on March of 23, so that is 10 and a half years. but it was filed prior to the new law.
Can I renew it?
Well, here's what I'm going to suggest. Why don't you file a motion to amend it to expungement, and the new the new law here provides that
Is it still under the 295332, Your Honor?
yeah, still in 53. 38 and 521. I'm sorry, 2953.32, and 10 years after it was eligible to be sealed. So file a motion that says that you're seeking to amend it from a motion to seal to a motion to expunge due to the change in law that went into effect on April the 6th after you filed this.
Okay.
And then the court's going to grant that. I'm not going to have another hearing or another investigation.
Okay.
I'll just go ahead and order it expunged.
Okay.
And then but we need to have it documented in the, for the record here to show that that's what happened.
Because obviously, I'll admit it, by dumb luck, I got the correct statute and the correct stunt. I just need to refile it so it's time stamped properly.
Yeah. I have there's a memo from the Ohio Criminal Sentencing Commission that, and chart that just came out, which I'm looking at, my cheat sheet. And I'll have my assistant make copies of that and give it to everybody.
Yes, sir.
Because it gives you the explanation. Now there's an unlimited number of offenses that can be sealed. In fact, now they make it basically eligible offender, and then they only define those offenses that are not eligible, which are F1s, 2s, sex offenses, certain offenses, OVIs and all the traffic cases are not. Those are, but anyway, so here's what you file a motion to amend it from a petition to seal it to expungement, and under the new statute, and I'll go ahead and then sign it at that time.
Thank you, sir.
And then, like I said, this new rule then will provide that these records will actually be destroyed, Mr. Ritter.
Okay.
But keep copies of that entry, because that'll be the last one. If you lose it, it can't be replicated because they're all going to be destroyed. Yeah. Okay?
Thank you, Your Honor.
All right. It may take about 30 days for all that to get done at the BCI and FBI, the Sheriff's Department. Was that the case? The whatever investigating office agency, BCI, it'll maybe take 30 days for that to happen. Okay. And did you pay your $50 sealing fee?
I think we did it when we.
Okay.
I don't know if we filed it with it or not, Your Honor.
Well, check. I think you probably did, but check to make sure.
We sometimes do.
Okay.
Thank you.
Thank you, sir. So we're not going to come back.
Right.